Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 4 of Term 2 2017. This week, the specific topic is mediation, and it's based on Chapter 3 of your textbook. So the text is excellent. It's easy to read. I expect that you will be able to read all of this quite comfortably, and I would hope that you're getting ahead of your reading. The reason I'm particularly keen for you to get ahead of your reading is that there is no one solution to ADR practice. And as I mentioned, I think in week 1, it may be that during the course of the take-home examination, you need to draw on skills from a range of ADR disciplines. That may not be the case, but I do want you to understand a range of the disciplines, even though in the early weeks we're concentrating very heavily on mediation and conciliation. The other thing that you might consider is beyond your studies, developing an association with important bodies. One is the Queensland Law Society, and that's an application for student membership. It's something that you might want to consider. Another aspect of becoming familiar with people in the profession is joining groups in community legal centres, and if you have access to do so, I'd encourage that as well. If you need some guidance on any of these issues, please ask questions through UCrew or share information, and we can go from there. I'm very heartened to see that most people have got their groups organised for Assessment 1. Assessment 1 is, of course, the mediation or conciliation session, and even though you're working in groups, it's not a group assignment. I'm marking you on your work as the mediator or the conciliator. You're there to assist each other and provide guidance to each other, as well as playing parts in the role play. If you, for whatever reason, can't find or don't wish to join with members in the class, then you can bring in outsiders, third parties as I call them. So my main aim is to ensure that you have the mediation session or the conciliation session, irrespective necessarily of who the people involved in the mock dispute are. However, if it's people in the class, so much the better. To assist you in getting a feel for what's involved in an audio-visual presentation of a mediation, this week on UCrew, I uploaded a video from the Family Court of Australia. It's a role-play mediation that's between separated couples on parenting arrangements, and it ends with a discussion on the role of the lawyer in the mediation process. So do take some time to look at that. I suspect also that many of you have come across other pieces of information about what's involved in the mediation process, perhaps some examples of mediations, and if you do and you find something that's worthwhile, please share that with your classmates and put a link to that material or upload that material onto UCrew. So what's involved in a mediation? Well, I guess the first thing that I want to do is take one part of the mediation, which is very important, and go through that with you briefly tonight. You'll need this skill specifically for your first assessment. And essentially, when I talk mediation, you can take that as also including conciliation. As you've guessed, they're pretty close, particularly in the early stages of the process. So what do I say when I'm introducing a mediation session to parties? Picture now the situation that we've arrived at a mediation venue. The first thing that you should do as a mediator or conciliator is ensure that you're the first one there. Make sure that the tables are set up, the drinks are ready, the room is quiet and comfortable, there's enough chairs, seating. Make sure that if there's a blackboard that you intend to use, that it's there, ready to go. Make some arrangements for printing. There's a practical reason for that. You want an agreement to be struck, and that should be reduced to writing normally, where you've got a lawyer involved in the process or lawyers involved in the process. And rather than have it handwritten, I think it's much more professional to have it typed. So if you're there with your laptop, for example, make sure that you've got some access to a printer. Take your printer, or pre-arrange to have access to a printer. I always have a bag that I take with my computer in it, and I always have a USB stick. And surprising the number of times that I've had to actually use that USB stick or perhaps email to be able to make that printing arrangement. So the point is that it's your job as the mediator or the conciliator to have everything set, ready to go. It provides that level of comfort to the participants that you're on top of things and you know what you're doing. So, but even before you get there, as part of the pre-mediation process, there are a number of things that you need to do or consider, and we'll go through those later. But for the moment, let's assume that we're at the mediation venue. You've arrived first. You've got the logistical aspects sorted. You now wait for the parties to arrive. When they arrive, there's an important aspect, and that is that you don't want to start the mediation process unless that is your specific intention, with only one party rather than the other. There is an issue in terms of intake, and the intake process can occur to some degree on the morning of the mediation. But make sure that you've planned your process. In other words, it's very dangerous to start embarking on discussions about substantive matters involving the mediation when the first of the parties arrive, because it creates a terrible impression for the second party or the third party, depending on the number of people involved in the dispute. They arrive, they see you discussing this matter with one of the parties that they're in dispute with. Suddenly they think that as the mediator or conciliator, you're on their side, and it puts everything on the back foot. So make sure that you're very careful about your communications. Make them, generally speaking, if in doubt, make them very professional, make them procedural only in terms of welcome to the mediation session, waiting for the other party, I'm John, introduce yourself perhaps, and then invite them to take a seat. You should probably have organised 2 areas which you can reserve for the parties to engage in their own private discussions or discussions with you during the mediation session in the private session. So introduce them to their room and then take them into their room and just ask them to wait until the other parties arrived. When both parties have arrived, take them into the room and be careful about the seating arrangements. Generally, I will sit at the head of the table. That's not a power thing, although perhaps it is. But really, it's a location where you can see people easily. If you have people seated directly to your left or your right, it's very hard for you to pick up on those little visual cues or other things that might be very important to assist you, to assist the parties, to come to a resolution of the dispute. So when you're doing your mock mediation or conciliation, ideally, if you can, you would do something of an introduction and make some arrangements for the seating. Now, of course, if you're doing this online, that's practically impossible to do. So just be aware of that in terms of what we would normally see in a face-to-face mediation session. Once the parties are seated, we then go through a number of introductory comments. You can add your own, and there's no set formula for this. But I tend to start with something about myself. Introduce my name, my role, if I'm appointed by a particular body, advise that I have been appointed by that body or that court, whatever it might be. I think it's important that you demonstrate a willingness to listen and be seen to be helpful. So at that stage, I try to avoid looking down at notes, try to make eye contact with people, try to engage with them. Smile is always good. And thank them for attending. It's a big thing for parties to come to a dispute where they're involved in a dispute with the people that are sitting opposite them. Now, I might say that I'm there as the mediator, but I'm also, say, a barrister, but I would make it clear that I'm not there as an advocate on that occasion. I'm there as the mediator or the conciliator. And I would seek to establish that I've had no previous contact with anyone involved in the dispute other than what you disclose. Now, what you disclose may be that you've had previous contact with them in some minor way or incidental way, but certainly not acting for them if you're a lawyer, and make sure that everyone's comfortable with that. So, for example, if you're dealing with a franchise dispute, it may be that you see the same legal representatives who represent the franchisors on a regular basis. So there's nothing wrong with telling the franchisee in that particular case, look, I have dealt with the franchise disputes before. I do know the lawyer for representing the franchisor. Can be the other way around. So make sure that if there is some previous contact, you at least acknowledge that and disclose it. It may be that during the intake process, you've had some previous contact as well, and that's something that you should disclose, but the parties would almost invariably be aware of that because you would have done that sort of intake process equally, hopefully, between the parties. So, having introduced myself, thanked the parties for attending, and given them some idea of my role in that process, I then move on to explain the process. I normally advise the approximate time of the mediation, just so that parties are aware what the time period will be. You don't want a situation where some parties think that the mediation will take half an hour and another party thinks it will take half a day. So whatever it is, that's probably something that should have been sorted in the intake, but you don't want a situation where after 30 minutes into the mediation, someone announces for the first time, oh look, just to let you know, I've got to pick up the kids in 15 minutes. That's information you needed right at the start. So you might say, look, I expect the mediation will take in the order of 3 hours. Do you have any time constraints? What's your expectation, etc.? You need to identify that the process is one where you want the parties to have authority to settle. You are there to assist the parties to settle. You want the parties to acknowledge that they're there with the authority to make decisions. And what you don't want is for the whole thing to settle, and then after 4 hours of discussion, one of the parties says, well, that's all very well. I'll now take it over to my boss and we'll have an answer for you in a week or two. Again, you want to have that information at the start. Generally, I conduct mediations using first names. That's not always the case, but generally that's the case. I actually say I've got a preference for using first names. Does anyone have a problem with that? Sometimes people do. And you'd be, perhaps it would be unsurprising for me to say that in many mediation situations, people refuse to talk to each other by their first name, and they'll use the formal name but in a passive-aggressive manner. Well, Mr. Smith would very much know, using that tone of voice. The reason I like to use first names is that as a mediator, to some degree, you are trying to create a connection between the disputing parties. You're trying to allow them to have and retain ownership of the dispute. And that's a shared thing between them. It's a common point of interest that they have this dispute. Let them have ownership of the dispute. Let them communicate directly with each other. Pave the way by allowing them to use their first names. And in fact, giving that as your preference, that people used first names. Doesn't always work, but sometimes. And while you're doing this, you're trying to maintain eye contact. You're trying to limit your note-taking to the barest you can. So, two things come of that. The first is that if you go into your mediation session, you may have some prompts to remind you of the things that you want to say in your opening statement. So have that sheet there, but have it in such a way that ideally it's not obvious to the parties that you're working off it, and certainly try not to read it. But the second thing is you want a sheet where you can write information. And what I usually do is immediately write the names of the parties as they're announcing them, trying at the same time to maintain eye contact the best I can. And a little tip here is write the names relative to where you're sitting in line with the party that you're talking about. So if you've got the first person who addresses you is sitting 45 degree at your left. Then on your sheet of paper, write that person's name 45 degree on their left, so that as you look to them, you can look down and see their name on the way through fairly discreetly in case you've forgotten it. Likewise, if you've got parties to your right, write their names in roughly that line so that you're not getting them confused. Okay, so now the parties have some idea of the sort of informal process. I mentioned that you might tell them that you are, say, a barrister or a solicitor or a mediator or whatever it might be. But it is important that they understand specifically your role. You are there to hear their dispute. You're not there as a judge. You're certainly not there as some sort of jury, but you are there to assist the parties by identifying issues of concern and to assist them in resolving the dispute. As I've said, and I keep mentioning this, encourage the parties to take ownership. And I actually use that term quite often. And I'll sell that term on the basis that they have a valuable asset. This dispute is theirs. Don't give it away lightly. Here is your chance to keep control of it. It's yours. Okay, so what's the specific process? I indicate then to the parties that this is what they can expect. I'll hear from both parties in turn, without interruption, by way of relatively brief opening statement. And I thank the parties for their cooperation in not interrupting each other while they give those opening statements. I actually say to parties, look, if you hear something that prompts you to wish to say something, make a quick note of it to remind you about that comment or question that has come to your mind, but don't interrupt them while we're doing the opening statements. I indicate that once we've completed the opening statements from all the parties, I will, with their help, set an agenda which we can use before we embark on discussions. I indicate that once we've embarked on those joint session, most likely we'll move into private sessions. I explain the nature of the private sessions briefly. That is that I'll talk to the parties in turn, hopefully for a roughly equal amount of time, and stress, and this is really important, that during those private sessions, anything which is said to me or anything which is discussed between us remains confidential in that private session setting. In other words, I won't, without their permission, part with any information that I gain during the private session to the other side. Sometimes parties will say, well, will you take an offer for me, or will you tell the other party something? We'll get to this a bit later, but I always resist that. And the reason I do is I don't want to become a broker, as in having two parties in separate rooms, using me as the medium to exchange offers. I want them to retain ownership of the dispute. So once we've had the private sessions, I will tell the parties that in all likelihood, we'll go back into a joint session, and hopefully at that stage, we can start making some offers to each other to resolve the issue. I'll then indicate that once we've been through that second joint session, hopefully we've got a resolution where, together with their lawyers or with them, I will assist the parties in drawing the agreement and signing the agreement. And I make it clear that my expectation is that where there is an agreement struck, it will be signed as part of the session. If they wish, of course, to obtain advice in relation to it, I encourage them to have their lawyers or accountants or whoever it might be, their managers on an availability situation so they can get that advice and sign it there and then. So that's my brief explanation of the mechanics, the process to the parties. It's important during this opening statement that you explain to the parties that this is a confidential process and that what is said by the parties with a view to resolving the issue, things that might be by way of compromise or offer to settle or novel solutions, remain confidential to the process and they're without prejudice. They can't be used in later proceedings. I explained that part of the reason for that is this. Knowing that you can make an offer safely, that you can provide a suggestion safely, that you can concede something safely within that encourages discussion. It also encourages novel solutions, and it provides them with more ownership of the dispute. You see, in a litigation section, there is a bit of a mindset that to some degree people want to keep things close to their chest. They want to keep their powder dry, to use some of the terms that we hear. So they don't want to tell people. They don't want to make concessions. They don't want to appear to be weak. In a mediation session, you've got to encourage the parties to embrace this opportunity to actually be honest and upfront with each other, because that's our best way to resolve the issue and come to a settlement. On that point, I encourage people to think about exchanging offers, to make compromises, and I say to them that it may well be that if you resolve the matter, you may leave here a little disappointed. And if that happens to both of you, if you're both a little disappointed, then maybe we've settled at just about the right spot. But being a little disappointed will quickly turn into a great deal of relief when, for example, you wake up the next morning and the matter is behind you. It's settled. It's over and done with. And that's the sort of groundwork that I might use when discussing what we hope to achieve during the mediation during that opening statement. I do explain that everything is confidential, but if there are threats, then, and that confidentiality binds me, but if there are threats, that's an exception, and I may have to make disclosure of that without the parties authorising me to do so. I've never had that situation occur. And then, as part of my close to the introductory statements, I'll ask the parties if they have any questions, if they're ready to proceed. And then we'll proceed. And we'll talk about how we proceed and deal with the party statements in a moment. But that's my take on what a mediator should say in an opening statement. You need to do your own. Everyone will have a different style. There are some things that I want to see in that opening statement. For example, if you fail to mention to the parties that the process is confidential and that what is said can't be used in later court proceedings, you will lose marks. I think it's safe if you haven't already done so, if you start to write your own opening statement with a view to then reducing that to a series of dot points, or if you've got a really good memory, memorise them. But make sure that you cover probably most, if not all, of the basic issues that I've talked about tonight. And look, there's lots of material. Spencer has his take on it. If you go on the internet, you'll see lots of different ways that people go about preparing their introductory comments for a mediation. Are there any questions? Any comments? We've all been very quiet tonight, patiently listening to me. Nothing? All good? All right. So let's move into the process for a mediation. We've provided the parties with the introductory statement. They now know where we're going, what the ground rules are, and how long it's likely to take. Well, look, speaking of other ground rules, some people say, make sure that and I think actually this is important, I probably should have said this. If you want to speak to someone to get advice, then please let me know. If you need a break for any reason, please let me know. Bathrooms down there, etc. Okay, so we've done our introductory statement as a mediator or a conciliator. We've told the parties that the first thing that we'll do is hear from them, one after the other, by way of opening statement, and we've asked for the commitment of the other party not to interrupt. The reason I ask for that is we've got to try and get the issues down. We've got to come to some agreement. We need to maintain some control. And you've got to remember that the parties are there in different circumstances. Sometimes the parties that are there are ready to pounce on each other, sometimes literally. So there might be some security issues as well that you need to consider before you go into a mediation. I forgot to mention that. And the parties might be ready to explode. And having the commitment that they don't interrupt each other during that opening statement means that we're keeping things productive and under control. So who should give the opening statement first? Do you go alphabetically? Do you go with the party that brought the dispute to the attention of you or the people that you have engaged you to do the mediation? Do you go with what's the consensus? My personal view is that if a party has brought the matter by way of action in litigation or they have requested the mediation, they should go first. But there's no hard and fast rules. Other people choose a different way of doing it. So I will start by saying something to the effect, Mary, you've brought this dispute to court. The court has referred it now to mediation. As the plaintiff, I'm going to invite you to give your opening statement first. Explain why you chose one party rather than the other, because at that early stage, people are very heightened, they're very sensitive, and a little thing like who I choose as the mediator to go first may be perceived by the other party as a bias. And an apprehension of bias is just as bad as actual bias in the minds of the party. The opening statement from the parties should be relatively short, but here's some problems. Parties aren't necessarily great at providing an opening statement. I mean, ideally, what you want them to do is follow the IRAC method or the MIRAC method, depending on which acronym you like. So you would like them to identify concisely the material facts in issue, the legal issues, and not necessarily, I probably shouldn't have said IRAC, but you want them to identify the material facts and the issues and their position in relation to these things and what they want to achieve. I mean, that's what you really want them to do. So sometimes you can ask them, or sometimes you can say to them, this is what I want from your opening statement. And we'll have plenty of room to expand on this, but just the basic version first up, if you would. Sometimes people are really good at it. Other times they're just going to wander off on all sorts of tangents. You really don't want to interrupt them during their opening statement, but sometimes you just have to guide them slightly, but do so very carefully. The last thing you want to do is become, involved in the parties giving their opening statements. When you've asked the other side not to interrupt, you don't want to be seen as breaching your own rule. Anyway, the parties give their opening statements. You've received a commitment from them to write their questions or comments on their own piece of paper if they wish to respond to something. You then try to work with the parties together to create the agenda items. 3 or 4, maybe 5 is what I like to work with. And ideally, the agenda items are a word or a phrase, not a paragraph, not even a sentence. That's too cumbersome. So, whatever key issues there are, try to identify those issues. Now, in a 15-minute mediation, you'll probably have one issue. You won't have time to discuss 3 or 4. So your agenda might be 1. But just for the sake of getting points for your assessment, make sure that that you make it clear that to me that you know about the agenda, because I'll be looking for that, and I'll be looking for you to assist the parties to identify the issue or the issues. So it might just be one word, and you might say, all right, well, thank you both for your opening statements. With your assistance, I'd like to create an agenda. The agenda is really just identifying the key issue or issues. Having heard from both of you, it would seem to me that the issue here is, what do we do on Saturday nights? Whatever that, if that's the dispute. Do you agree with that? That's our only issue. That's our only agenda item. Yes, and then you can get into it. It might be 2 or 3. but in 15 minutes, you're not going to have time to go into it much. All right, so having established the agenda, and I'm using the terms agenda and issues somewhat interchangeably here, because what you really want is you want the agenda to be the issues that are important. You don't want them to be the things that will cloud the discussions. So the issues might be the agenda items. Ideally, probably they are 3 or 4 or 5 of those. Once you've established the agenda items, and the idea is that frames the dispute. Again, what you don't want is a situation where 2.5 hours into the mediation, after going through the agenda items carefully, one of the parties says, oh, look, there is another really important thing that we need to discuss today, and that is the issue of, stock being provided to me out of date. You think, man, that's something that we should have put on the agenda right at the start. So if that happens, it's not a great reflection on the mediator or the conciliator, because your job is to obtain a commitment, an agreement from the parties that this is the agenda, these are the disputes, and draw that out from them. Assuming that we've got our agenda, we've got our issues sorted, 1, 2, 3, 4, up on the blackboard or whatever it might be on a piece of paper. I actually write it on a middle piece of a paper, put it in the middle of the table in a face-to-face situation. And that way I can look at it and say, okay, here's number 1. Agenda number 1 is the issue of telephones not working, whatever it might be. It doesn't matter. Part of the reason for that is I actually want the parties to look together down at the table and see that item. It creates a point of agreement for them. They're now both looking at the same thing. They're looking at the problem, and it's a start, it's a precursor to actually trying to solve the problem. So we've identified the agenda. You can, if you wish, as a mediator or conciliator, ask the parties which of the matters that they would like to discuss first. I generally just work from the top. And the reason I say that is that in creating the agenda, in helping the parties to create the agenda, I've done so in an order that is probably logical in terms of chronology or some other form of logic. So we normally start with number 1. Now, here's where it can get interesting. This is where the parties can really blow up, and you've got to be on guard. You've got to be ready to go and have your mediator toolkit ready at your disposal. Because once we open it up for the parties to discuss with each other, we sometimes see the opening blows, we see the emotion fly out, and there's a great risk of a walkout within that next 5 minutes. Someone will say, blah, 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 they'll blow up, and you've got to be ready to move in. There's no one right answer for that. There are a few things that probably you shouldn't do. You shouldn't allow the matter to escalate. Remember sponging? If someone really wants to blow up and have a say, you're going to have to absorb that pressure yourself if you can. So while you're keen to encourage the parties to talk to each other, at the start, if there's a blow up, you might want to just say, hang on, tell me about it. And just physically maneuver your chair and look at them and encourage them to look at you, and just leave the other side out of it for a moment so that they're not absorbing the attack. So they're starting to look at you, and they're providing you with their issues. You don't want that to go on for too long. That's only a temporary thing. So whatever tools you have at your disposal to deal with those sorts of issues, keep them ready at hand. During the joint session, we're talking about things that are important to the parties. We're trying to encourage them to do a few things. One thing that you can do is ask clarifying questions. So, open-ended clarifying questions. Okay, so we have an issue with the quality of the merchandise. Tell me more about that. Why is it that there is a problem with the technology? And what we're trying to do is ensure that the parties at least understand each other. They may not agree with each other, but sometimes you can actually see it happen. You can see one of the parties go, all right, oh, I understand. now I better understand your problem. Once you've got the parties committing to better understanding each other's situation and problem, we're a much better chance of having an agreement. During that time, it's likely that we won't settle. It's not likely that we'll settle. And at some stage, you'll probably want to call for private sessions. Be very cautious not to do that quickly. You want to keep the parties in joint session productively as long as you can. So if you can keep them in a joint session for an hour or two, depending on the extent of the mediation, there's nothing wrong with that. What I don't like is the sign of a first blow up, the mediator panics, fears a walkout and says, all right, well, obviously emotions are very high. I think we'd better separate now, just so we can cool down. You know, try not to do that. You're taking the dispute from them and you're putting them back into adversarial mode. Whereas we've got to work through that, keep them together if we can. But eventually, you'll probably go into a private session. If you go into private sessions, announce to the parties once again that you'll try to make the private sessions for similar periods of time, and that if you're with one party, you'll try and be with the other party for the same amount of time. Whatever is said to you, whatever is discussed remains confidential between those parties. Then when you've finished your private sessions, come back into a second joint session, and hopefully that's when you have the agreement. Now, in those private sessions, it's likely that you, as a conciliator particularly, you'll be doing some reality testing. You certainly do that as a mediator as well, but you're probably looking to provide some sort of advice or guidance, which is reasonably pointed perhaps. So generally speaking, in a conciliation or a mediation where there is an advisory element to it, you would normally have a mediator that has some experience or expert knowledge in terms of the area that you're talking about. When you're in those private sessions, it's a really good opportunity also to find out things that you don't know. As Donald Rumsfeld said, and I'm paraphrasing, that there are things that you know, there are things that you don't know, and there are things that you don't know that you don't know. Does that make sense? So in the private sessions, you want to try and find out the things that you don't know because you don't know them, if that makes sense. And it's surprising how, with a little bit of digging, you can find things out that will help. And all of this means that you're in a better position to break deadlocks. Sometimes parties are just not budging very much. So just as a segue, what do you do then if the parties are not budging? If they're in a deadlock, it's very easy as a mediator to say, oh, well, obviously we're not going to settle now, so good on you for giving it a go, and all the best, and we'll see you next time. I think there's better things we can do than that. One way to break down a deadlock is to try and break down the dispute into sections. In the slide, there was the mediator with the two animals, the two dogs. You know, can we agree that it's a big backyard? So try and get some point of agreement. Okay, what are the facts that we agree upon? Okay, we understand there's a deadlock, but there must be some points of agreement. Let's get these points of agreement down now. And that then easily leads into a session of saying, now let's identify together the points of disagreement. We know you don't agree, but I want to identify clearly the points of disagreement. If they resist that, you say, this will help you in future litigation. If you can identify the points of disagreement, you're in a much better chance of resolving the matter in a short trial rather than a long trial. But once you start to do that, once you start to get them agreeing, you find points of agreement, suddenly they start to agree on things that were seemingly deadlocked and in a situation where they couldn't move further. So try and break things down. When you're doing your reality testing, and I know I'm jumping a bit here, but when you're doing your reality testing, just remember, of course, that part of it might be to have the parties think carefully about whether they're going to win the battle but lose the war, if you know what I mean. By that, it might be that someone has a good claim, is not willing to compromise. My claim is $100,000. I want $100,000. I'm not settling for anything less than $100,000. In the private sessions, without disclosing confidential information, I guess you can always ask questions like, have you made inquiries as to whether, if you're successful, it's likely you'll receive the $100,000? Or is the party you're pursuing a party without the funds to pay the settlement? I mean, it might be that that's the reason that they're not settling, because the party just doesn't have the money, so they're embarrassed. Anyway, they're the sorts of issues that you can consider during those private sessions in particular. I'm doing a lot of talking. Are there any questions? We're all good? And you need to have modified versions of these things ready to go for your mediation or conciliation session. All right, so we know that the process is flexible. There's no one right or wrong way to do this. And we know that mediations can be of different types, and they're based on different types of negotiation. So we've talked about principled negotiations, and that's the one that you probably want to work towards most commonly. Some tips. Firstly, always try to encourage the parties to think about their interests rather than their positions. Use those terms. What's your position? I want a pay rise. What's your interest? I want a better home life and I want some recognition at work, whatever it might be. That's what's really important to me. Think about, encourage the parties to think about their best alternative to a negotiated agreement or their worst alternative to a negotiated agreement. Their BATNA and their WATNA. And encourage the parties to think about their goals now, next week, next month, next year. Sometimes if you explore those things, particularly in private sessions, it becomes apparent that the last thing they want is this litigation that's facing them. It gives you a better chance to identify some things. Okay, I'm just going to give you a list of things now that you might want to jot down as, if you like, further skills for mediation. So firstly, the process, how you greet the parties, the level of comfort you give to them, and in your statement, make it short, but make sure that you talk about some key points, the mediator's role, talk about the no advice rule, if that's appropriate for the mediation, confidentiality. So those are things that you really have to get down. When you're involved in the parties giving their opening statements, I'll be looking to see if you manage interruptions. And once we, and while we're doing that, we're looking to ask exploratory questions to set the agenda. I'll be looking to see how you summarise and, if necessary, how you reframe and how you sponge. When you're doing the joint session, I'll be looking to see how you encourage the parties to provide input, how you control the process, who speaks first, how you decided to do that. And I'll be looking all the time while parties are talking at your active listening skills and whether you're acknowledging the parties and whether you're reframing and summarising well. I'll be looking to see your use of open questions and whether you're asking the sort of what if type questions or the tell me more about type questions to elicit information and get the parties thinking laterally. So be looking to see if you're using open questions and dealing appropriately with emotions. I'll then be looking to see if you're moving into separate sessions at an appropriate time. I'm actually going to scrap that from the list of things because in 15 minutes, you may not have time to go into private sessions. You probably won't. So that would be an unrealistic expectation. But if you do go into private sessions, you need to ensure that they're aware of the confidential nature of those sessions. I'll be looking to see if you encourage the parties to retain ownership of the dispute, and if you are able to perhaps use some other techniques like the use of silence. I'll be looking to see if you provided equal attention and balance between the parties, and whether you were able to keep the process moving, but at the same time not take the dispute from the parties. They're kind of some of the skills. We talked about those skills over the last 2 weeks. And I'll be looking for your general demeanour. Were you focused on the task? Were you relaxed? Did you remain unruffled? But at the same time, you were approachable, confident, and empathetic. So your communication skills come into it. What you don't want to be doing is looking down at your pad the whole time. You need to learn how to write some selective notes, but do so without detracting from the eye contact and the engagement that you have with the parties. And there it is, it's simple. Did we get all that? Now, we're not going to have a night where there's 0 questions or 0 comments, are we? Is that what I'm looking at?
Oh, I've got a question, John.
Oh, thank you. Thank you, Mick.
In relation to your opening statement, prior to going in there, I may have missed this, but just wanted to confirm, is it generally acceptable to have private sessions before you go in, and then in your statement you mention from those private sessions that what our general discussions were just in relation to coaching them before you get them in there?
Yeah, look, that's a really good question, and I did mean to address you more on that. I talked about the pre-mediation process. It's not always necessary, and in your assessment you won't have time for a pre-mediation process, but in a way, when you're chatting with the people that are involved in the dispute and you're talking about the dispute, that will be the pre-mediation process. It's just that that's not examinable, that won't be accessible. But in real life, generally speaking, I have a pre-mediation session with both parties. Sometimes it's just a meet and greet. It may be over the telephone. Audio-visual's better if you can't meet them in person. But it's just a way of saying, look, you know, I'm here, I'm the mediator, I'm here to help, but I'm also here to encourage you to work hard. And I want you to think about the issues and think about what life will be like for you if we settle, what life will be like for you if we don't settle, and prepare. You know, in the last 2 weeks I've been all about what are the things that you need to do to prepare before you get in. So sometimes the intake is a very gentle encouragement for people to prepare appropriately. I do talk about the issues privately with the parties before we go in, but it's very much me just receiving information. And I tend to keep that information to myself. I will say, look, and I will announce that whatever they tell me is confidential between us, but I will encourage them to say a lot of these things during the mediation session because it's important that they do so.
Is that a good opportunity to coach them on what their opening statements are going to be?
Or you've got to be really careful about that, again, for a couple of reasons. They may well be, and hopefully they are legally represented separately in any event, so that's a matter for their lawyers to determine. And coaching is a really touchy word because, you know, when it comes to litigation, you know, we never want to coach witnesses. So as a lawyer, you're always thinking, oh, coaching, that's a really dangerous word. But yeah, I get what you mean. What you want to do is perhaps encourage the parties to think about it, not necessarily tell them what to say, but perhaps you can give them some guidance as to the process and what they can expect is probably a better way of putting it. But thank you.
Yeah, okay, cheers.
Great, thank you, Anthony. All right, so the dispute does not have to be a legal one is one of the questions that's come through on the chat facility. When I give little examples, I try to make all sorts of things, but it can be a commercial dispute, it can be a neighbourhood dispute, it can be bankruptcy dispute, whatever it might be. It can be a dispute between the kids, I guess, trying to mediate that if you want to. Any other questions or comments? All right, so thank you, Anthony or Mick. I still haven't decided what I'm calling you yet. For those questions, that was really insightful. Excellent questions. Anything else? Good. All right. We might wrap. Yes, Paul?
John, just one question. You're in the mediation, and I guess it may be in a private session, and you know, you're being asked advice. Where do you go with that?
Again, there are different models for mediation. In the pure facilitative form of mediation, if that's what you choose to do, then you would steer away from giving advice. You might encourage the parties to think about their options and to think about things like what will happen in the future. Where it's a conciliation, generally you can provide advice, and a hybrid, which is almost a conciliation, is an advisory mediation model, where the mediator does give advice. And I think, was it Anthony last week, or someone said that they actually sat in on a mediation session and they were sort of surprised at the extent to which things were said. So sometimes it's a matter of terminology, Paul. There's not necessarily a right or wrong answer, but part of the intake process is to try and set some of those rules and give them an idea of what you're proposing to do as the mediator or conciliator.
Right. Thank you.
Thank you. All right. All good? No other questions? Okay. Thank you very much. Week 5 next week, I think we're dealing with conciliation, and good luck with your assessment. Hopefully you've had some meetings with your partners and you're now well into discussing. You should have your dispute pretty much organised, and you should be talking about that dispute with your partners. So plenty of time, but make sure you get it done sooner rather than later. Okay, all the best. See you next week. Bye.